Hi everyone, we are still on the series of lectures on property and land laws. Okay, our topic for today is easements. Okay, what are easements? Under Article 613 of the Civil Code, an easement or servitude is an encumbrance imposed upon an immovable for the benefit of another immovable belonging to a different owner. The immovable in favor of which the easement is established is called the dominant estate, that which is subject thereto the servient estate. So, easement is a limitation on the ownership, on the rights of ownership of the owner of the dominant estate. When we speak of easements, we necessarily speak of two properties. One is the dominant estate, the one who enjoys the easement, and the other is the servient estate, the one who is obliged to provide the easement. Okay, so if there is no dominant and no servient estate, does it necessarily mean that there can be no easement without a dominant and a servient estate? The answer is no. Okay, because Article 614 provides that servitudes may also be established for the benefit of a community or of one or more persons to whom the encumbered estate does not belong. So there may be easements in favor or for the benefit of a community or for the benefit of particular persons without necessarily owning the property to which the easement is established. Okay, example of which would be personal easements or the easements which are established for the benefit of particular persons, not for the benefit of a particular property, which is the dominant estate. Okay, um, can easements be imposed on personal property? The answer is no. Easement is always imposed on real property. It cannot be imposed on personal property. However, servitudes may be real or personal, while easement is always on real property. Now, what are the kinds of easements? Easements may be continuous or discontinuous, apparent or non-apparent. Okay, what are continuous easements? The determination of whether or not an easement is continuous or discontinuous would depend on its use. Okay, if the use of the easement is incessant, meaning they are continuous and does not depend on the intervention of man, okay, they are considered as continuous easement. On the other hand, if the easement is used at intervals and would depend on the acts of man, then it may be said that the easement is considered as discontinuous. What are apparent easements and non-apparent easements? Apparent and non-apparent would depend on whether there exists an external sign that would signify that there is an easement. Okay? An apparent easement is one which has external signs that reveal the use and enjoyment of the easement. On the other hand, a non-apparent easement shows no external indication of their existence. They exist, but they are hidden. That is why they are considered as non-apparent easements. Easements may also be positive or negative. A positive easement is one which imposes upon the owner of the servient estate the obligation of allowing something to be done or of doing it himself. And a negative easement, on the other hand, is that which prohibits the owner of the servient estate from doing something which he could lawfully do if the easement did not exist. Okay? We now go to the nature of easements. Okay? The nature of easements are as follows. They are provided under Articles 617 and 618. Okay? Easements are inseparable from the estate to which they actively or passively belong. So the element of inseparability. You cannot detach it from the estate. Okay? Easements are also indivisible, the element of indivisibility. So if the servient estate is divided between two or more persons, the easement is not modified and each of them must bear it on the part which corresponds to him. If it is the dominant estate that is divided between two or more persons, each of them may use the easement in its entirety without changing the place of its use or making it more burdensome in any other way. So if it is the easement, if it is the servient estate that is divided, for example, it used to be one lot. Now it was divided into two lots. Does it mean that the easement is extinguished or modified? No. The easement continues. Each of them will bear the easement. Okay? It is also the same if it is the dominant estate that is divided. Okay? Each of the owners of the dominant estate, each of the owners of the dominant estate will have the right to use the easement. Okay? Article 619 speaks of another kind of easement. Easements may be legal or they may be voluntary. Easements are established either by law or by the will of the owners. If it is established by law, they are considered as legal easements. On the other hand, if it is established by the will of the owners, they are considered as voluntary easements. Okay. Another classification of easement is real or predial servitude as well as personal servitude. What is a real servitude? A real or a predial servitude is established for the benefit of the owner of a particular estate. A personal servitude, on the other hand, is established for the benefit of persons or group of persons without being the owner of a dominant estate. So the traditional easement is a real or predial servitude. Okay, there is a dominant estate and there is a servient estate. Whoever becomes the owner of the dominant estate, okay, will have the right to use and enjoy the easement. On the other hand, a personal servitude, since it is established for the benefit of persons or group of persons, without them being the owner of a dominant estate, okay, the owner of the servient estate may withdraw the easement if the said person or group of persons no longer need the easement because it is established for their own benefit and not for the benefit of the owner of the dominant estate. So when we speak of personal servitude, there is no dominant estate because it is personal to the persons or group of persons for which the easement was established. Okay, so an example of an apparent easement is, an example would be a right of way in which there is a path, okay, a visible path. Okay, on the other hand, non-apparent easement, since it has no indication of its existence, um, a right of way which has no visible path. Okay, in continuous easements, the enjoyment can be had without the intervention of man. The law classified the easement of aqueduct as a continuous easement, even if the use thereof is not continuous or the use thereof is not incessant. In this continuous easement, the enjoyment requires the intervention of man, example of which would be the easement of right of way, which is discontinuous and depends upon the act of man. An example of a positive easement is easement of right of way, which imposes upon the owner of the servient estate the duty to allow the use of the said way. An example of a negative easement is the easement of light and view, where the owner of a servient estate is prohibited from obstructing the passage of light. So the owner of the servient estate is prohibited from building a structure which would block the light and view of the owner of the dominant estate, coming from the window of the owner of the dominant estate. If the window is constructed in the wall of the owner of the dominant estate, then it is considered as a negative. However, if the window is established on a party wall, okay, it is considered as a positive easement because it the party wall is a co-ownership, okay, and it imposes upon the owner of the servient estate, the adjoining estate, the duty to allow the window to be kept open. Okay. Okay. Now, as I have stated earlier, the nature of easements would be inseparability. They cannot be sold or mortgaged independently of the estate. It has an independent juridical existence and is considered by law as an immovable property. It follows the property to which the easement is attached. It is like a mortgage. However, it is also a limitation on the right of ownership of the servient estate. So if the dominant estate is sold, the sale carries with it the easement, even if they are not annotated on the title, unless, of course, um, the easement is removed, okay, even before the sale of the property. Easement is extinguished by registration of the servient estate without the annotation of the easement on the title. If the easement was known to the transferee, knowledge is equivalent to registration. Okay, another character or nature of an easement is indivisibility. So the partition between two or more persons of either the servient or the dominant estate will not affect the existence of the easement, which continues in its entirety. Easement as a right is indivisible. This is the logical consequence of the easement being inseparable from the estate to which they actively or passively belong. We now go to the first case, Habonete versus Monteverde. Okay, this case speaks of a personal easement. Okay, one in which there is no dominant estate. Okay, because it was established for the benefit of particular individuals. So in this case, the right of way was granted to the family, friends, drivers, and servants, okay, as well as the jeeps, okay, that they own, okay, of the Serbian estate. In other words, the right acquired by the original plaintiffs was a personal servitude and not a predial servitude that inures to the benefit of whoever owns the dominant estate. So in this case, there is actually no dominant estate because it is a personal servitude. Okay? We now come to the case of Bogo Medellin Milling versus Court of Appeal. Okay, this case involves a narrow lot where the railroad tracks of Gomeco were laid. Okay, we speak of a sugar milling corporation in which there is a sugar milling site and there were railroad tracks that were passed through, okay, in order to go to the milling site, from the farm to the milling site. Now, Valdez filed a complaint for payment of compensation as well as recovery of possession of that narrow lot on which the railroad tracks were built. Okay, the trial court held that Bometco had been in possession of the narrow lot in good faith for more than 10 years. Thus, Bometco has already acquired it by prescription. But the issue is whether or not Bometco has really acquired the narrow lot on which the railroad tracks were built through prescription. Okay. However, it was discovered that Momedco declared the property to be a central railroad right of way or Sugar Central Railroad right of way in its real estate tax receipts. So in the tax declaration as well as in the tax receipts, they describe the narrow lot as a central railroad right of way. So when it is a right of way, it is necessarily an easement. Okay, now the question is, can an easement be acquired through prescription? So a person cannot have an easement on his own land since all the uses of an easement are fully comprehended in his general right of ownership. So it contradicted the claim of Momedco that they are claiming ownership of the land through prescription when they contradicted themselves by declaring the property merely as a right of way, okay, which is definitely not a claim of ownership because when you say right of way, it is a limitation on the right of ownership. An easement is a real right constituted on the corporeal immovable property of another by virtue of which the owner has to refrain from doing or must allow someone to do something on his property for the benefit of another thing or person. It exists only when the servient and the dominant estates belong to two different owners. Having held the property by virtue of an easement, petitioner cannot now assert that its occupancy was in the concept of owner. An easement is now the question that is now before the Supreme Court in the case of Momedco is whether or not the easement of right of way has been acquired by Momedco through prescription. The Supreme Court said that an easement is continuous if its use may be incessant without the intervention of man, and it is discontinuous if it is used at intervals. So, the Supreme Court said that the easement of right of way is discontinuous because it depends on the acts of man. It is considered as discontinuous because it is exercised only if a person passes or sets foot on somebody else's land. So the presence of railroad tracks for the passage of petitioners' trains denotes the existence of an apparent but discontinuous easement of right of way. Discontinuous easements, whether apparent or not, may be acquired only by title. Unfortunately, Bomedco never acquired any title over the use of the railroad right of way, whether by law, donation, testamentary succession, or contract. The presence of more or less permanent railroad tracks does not in any way convert the nature of an easement of right of way to one that is continuous. It is not the presence of apparent signs or physical indications showing the existence of an easement, but rather the manner of exercise thereof that categorizes the easement into continuous or discontinuous. The presence of physical or visual signs only classifies the easement as apparent or non-apparent. So in this case, the contention of Bomedco that it acquired the easement through prescription cannot be sustained because a discontinuous easement may be acquired only by title and cannot be acquired by prescription. And they were not able to present any evidence that they acquired the said narrow lot by title. Okay, so the contention of Bomedco was not sustained by the court. Okay. We now go to the case of NNSC versus Hidalgo. This is another case like Habonete. This is another case of personal servitude in which there is no owner of dominant estate, but it is an easement that was established for the benefit of a community. Okay. In this case, plaintiff is the owner of a site in which it is in which the sugar central is located, okay, as well as the residence of its employees. It is known as the mill site. Now, immediately adjoining the mill site is the hacienda sangay of the plaintiff, okay, where the defendant has a billiard hall and a tuba saloon. Okay, now the defendant used to pass through the road of the plaintiff because it was his only means of access to the hacienda. However, later, the plaintiff stopped the defendant from passing through the said road. Okay, with the cargo of tuba, plaintiff's gatekeeper would stop him and prevent him from passing through the road. Okay, now, of course, the defendant filed an action for injunction, okay, because he was allegedly being prevented from passing through the said road. Uh, the Supreme Court said that being considered as a public road, it necessarily follows that the owner of the land through which the road is laid out cannot maintain an action of trespass against any person using it. This is a case of an easement of way voluntarily constituted in favor of a community. Voluntary easements are not contractual in nature. They constitute the act of the owner. So if he exacts any condition, like the payment of certain indemnity for the use of the easement, any person who is willing to pay it may make use of the easement. So as long as he is willing to pay the toll, then he can use the easement. And the plaintiff cannot discriminate or screen the persons passing through the said road. Indeed, the latter may close it at its pleasure as no period had been fixed when the easement was voluntarily constituted. But while the road is thrown open, the plaintiff may not capriciously exclude the defendant from its use. Okay. We now go to the case of Solid Manila versus Yoko. Okay. So in this case, petitioner is the owner of a parcel of land which lies in the vicinity of another parcel. Now, the private respondent's title came from a prior owner, and their deed of sale, the parties reserved an easement of right of way for an annotation was entered in the private respondent's title. Now, the private respondent, however, constructed steel gates that precluded the unhampered use of the easement. So the petitioner had no choice but to file an action for injunction because they were prevented from passing through the said way. It is true that the sale did not include the alley through which the respondents pass through. The court rejects the petitioner's contention that the deed of sale excluded it because as a mere right of way, it cannot be separated from the tenement and maintain an independent existence. Servitudes are merely accessories to the tenements of which they form part, although they are possessed of a separate juridical existence as mere accessories, they cannot, however, be alienated. So as an easement, it operates as a limitation on the title of the owner of the servient estate, specifically his right to use. It did not acquire the right to close that alley or put up obstructions and thus prevent the public from using it. Because as a servitude, the alley is supposed to be open to the public. Okay? It is a consequence of the inseparability of the right of way. Okay, so when the sale was made, although it did not mention that the sale included the alley, okay, when the sale was made without any with knowledge, especially with knowledge that the alley is existing and there was no objection on the alley, okay, then the right of way continues, okay, to exist, okay, even if the said property has been sold to another owner. Okay, the servitude in question is a personal servitude, that is to say, one constituted not in favor of a particular tenement, but rather for the benefit of the general public. In a personal servitude, there is no owner of dominant estate, and the easement pertains to persons without a dominant estate, in this case, the public at large. So we are talking here of another personal servitude, one that is constituted for the benefit of a particular community. Okay? Merger also could not be considered as to have extinguished the right of way. Why? Because merger presupposes the existence of a prior servient dominant owner relationship. In this case, since there is no dominant owner because it is a personal servitude, there is no genuine merger that can take place that would terminate the personal lease. Okay? We now go to the case of PMO versus Legazpi Towers. In this case, Karuk previously was the original owner of 3 adjoining or contiguous parcels of land. Now, Karuk started to construct a condominium. Okay? And in order to construct that condominium, he has to obtain loans from the bank. So he obtained a loan from PNP, and as a security for the loan, he mortgaged the parcels of land. Okay. Now, while building the condominium, okay, Karuk constructed a powerhouse containing a generating set, and some pumps in the adjacent lot. Okay, however, because of Karuk's failure to pay the loan, PNB foreclosed the mortgage and acquired some of the properties of Karuk at the auction sale. Now, through the APT, the asset privatization, okay, the national government became the assignee and transferee of all the rights and titles in its receivables with Karuk. So including the properties it acquired from the foreclosure of the mortgage. Okay, now respondent filed a case for a declaration of the existence of an easement, okay, over the portion of the property that was being occupied by the powerhouse and the sump pumps. So out of the 3 lots, there was a lot in which the generating set as well as the sump pumps were constructed. Now, the Karuk, okay, sought for the declaration of an easement over the said portion occupied by the generating set and the sump pumps. Okay, so is that possible? Can an easement be declared over that portion of the property occupied by the said equipment? Okay, is it an easement, or does it qualify to be considered as an easement? The Supreme Court said that an easement merely produces a limitation on ownership, but the general right of ownership of the servient tenement must not be impaired so as to amount to a taking of property. When the benefit being imposed is so great as to impair the usefulness of the servient estate, it would amount to a cancellation of the rights of the latter. Remember, that is also a characteristic of an easement. It's only a limitation on property. You cannot impose a burden that is so great on the property of the servient owner so as to practically take, okay, the property. In this case, neither type of easement, legal or voluntary, was constituted over the subject property. Okay? When the appurtenances were constructed on the property, the lands where the condominium was erected, and the subject property where the generating set and some pumps were constructed, Article 6 belonged to Karuk. So there is only one owner of the 3 lots when this equipment were installed on one of the lots. Therefore, Article 613 of the Civil Code does not apply since no true easement was constituted or existed because both properties were owned by Now, when the subject property was assigned to the national government, that no easement arose or was voluntarily created from the transfer of ownership, considering that the parties, more particularly Karu, pledged that it was assigning, transferring, and conveying the subject property in favor of the national government free from any and all liens and encumbrances. So, there was no easement that was established because Karuk itself, when he assigned the said property, he assigned it free from all liens and encumbrances. Therefore, there is no valid easement that was established. Okay. Now, we now go to the case of Gutierrez versus Rojas. So, in this case, the petitioner applied for the registration of his property, free from all encumbrances, with the exception of an easement of right of way which he recognizes as existing. Now, in addition to the easement of right of way, the respondents claim that light and view and drainage in favor of their respective properties. He was claiming those easements. Now, the apparent sign of the easements claimed in this case is made to consist of a gallery with windows through which light is admitted. Okay? Her property as well as that of petitioner came from a certain Juan Bautista, the original owner of both estates. Now, at the time of constructing them, he established upon the latter estate not only an easement of right of way, but also the easement of light and view, which she claims, and that when both properties were alienated, the apparent sign of the existence of the said easement was not removed, nor was it expressed in the instrument of alienation. So when the construction of windows and balconies does not constitute an actual invasion of the rights of another, but is a lawful exercise of an inherent right, the easement of light and is negative. That is why earlier I said that if the window is constructed on the wall of the owner of the dominant estate, then that would be considered as a negative easement because it imposes upon the owner of the adjoining estate the obligation not to construct anything which would obstruct the light and view, provided that a notarial prohibition is served upon the owner of the adjoining estate or upon the owner of the servient estate. When an easement of light and view is negative, the period for prescription begins to run from the date on which the owner of the dominant estate, by a formal act, prohibited the owner of the servient estate to do something which he might properly do if the easement did not exist. We now turn to the case of La Vista versus Court of Appeals. Okay, this is a case involving a land which is in between Merinol or La Vista subdivision and Ateneo. Okay, it is in between Miriam College and Ateneo. Okay, La Vista is a residential village developed by the Tuasons. Okay. It prohibited the agents and assignees of solid homes from traversing the Mangyan Road. The Mangyan Road is actually a road, okay, which is established between a land owned by the Tuasons, which was sold to Philippine Building Corporation and later to Ateneo. Okay, Ateneo sold the 16 hectares of its property to Solid Homes. And the deed of sale provided, among others, that the vendor can pass unto the vendee the privileges of such right of way. In between kasi, the, uh, the, uh, the village as well as the school of Ateneo is the Mangyan Road, one half of which belongs to Ateneo, one half of which belongs to La Vista. The parties and their respective predecessors in interest intended to establish an easement of right-of-way over Mangyan Road for their mutual benefit, both as a dominant and servient estates. The opening of an adequate outlet to a highway can extinguish only legal or compulsory easements, not voluntary easements like in the case at bar. So you must remember, if the easement of right of way is one which is voluntary, one which is made to the will of the party, arrived at through a contract. Okay, then um, the opening of another outlet to the highway will not extinguish the easement. That is only applicable, that extinguishment is only applicable if the easement is legal or compulsory. And even if it is legal or compulsory, you have to uh, still, there is a need to go to court in order to close the easement if the owner of the dominant estate does not want it to be closed. Okay? A legal or compulsory easement is that which is constituted by law for public use or for private interest. Okay? In this case also of La Vista, it discussed that a legal easement, okay, can be granted if the four requisites uh, as follows are present. The estate is surrounded by other immovables and is without adequate outlet to a public highway. After payment of proper indemnity, the isolation must not due to the proprietor's own acts, and the right-of-way claim is at a point least prejudicial to the servient estate, and insofar as consistent with this rule, when the distance from the dominant estate to a public highway may be the shortest. A voluntary easement, on the other hand, is constituted simply by will or agreement of the parties. In sum, when the easement in this case was established by contract, the parties unequivocally made provisions for its observance by all who in the future might succeed them in the will. So it is binding even to their successors in interest. If it is because it is arrived upon, the easement is arrived upon voluntarily by agreement of the parties. And the said agreement is binding even with respect to their successors in interest. Okay? We now go to the case of Valdez versus Tabsuda. In this case, Valdez bought from Tabisula a 200 square meter portion of a parcel of land. Okay, it was agreed that they will be provided a 2.5 square meter right of way, but which was not included in the said sale. Now, the respondents built a concrete wall on the western side of the subject property. Okay. In this case, again, the Supreme Court discussed the two kinds of easements, legal as well as voluntary easements. Okay, from the allegations in the complaint, it is clear that what they seek to enforce is an alleged grant in the deed by the respondents of an easement. However, the proviso that the intended grant of right of way is not included in the sale would only mean that the parties would have to enter into a separate and distinct agreement for the purpose. Petitioners are neither entitled to a legal or compulsory easement of right of way, for to be entitled, the preconditions set forth under Article 649 and 650 must be established. Since the petitioners then have more than adequate passage to two public roads, they have no right to demand the grant by respondents of an easement on the western side of the lot. So that is the first and foremost requirement, adequacy. Meaning, is there an access to a public road? Okay? If there is an access to a public road, even if it is long, circuitous, inconvenient, it would not satisfy the grant of a legal or compulsory easement. However, you can still negotiate for a voluntary easement, provided that the other part, the owner of the servient estate consents to. What are the modes of acquiring easement? Okay. Continuous and apparent easements are acquired either by virtue of a title or by a prescription of tenure. Remember, this is the only kind of easement that can be acquired through prescription. Continuous and apparent. Okay? If it is discontinuous and apparent, you cannot acquire it by prescription, but you can acquire it by title. All kinds of easements may be acquired by title, but only continuous and apparent easements may be acquired through prescription. Okay, remember that, huh? Only continuous and apparent easements may be acquired through prescription. Okay, in order to acquire by prescription the said easements, the time of possession shall be computed in positive easements from the day on which the owner of the dominant estate or the person who may have made use of the easement commenced to exercise it upon the servient estate. In negative easements, from the day on which the owner of the dominant estate forbade by an instrument acknowledged before a notary public the owner of the servient estate from executing an act which would be lawful without the okay. All kinds, as I've said, all kinds of easements may be acquired by title. When you say title, it means a juridical act which gave rise to the easement. It may be by contract, it may be by donation, by succession, or by law. Okay, however, only continuous and apparent easements may be acquired by prescription. The law fixed the prescriptive period of 10 years, regardless of the good or bad faith of the person exercising the easement. Now, the commencement of which will depend on whether it is a positive or a negative easement. If the easement is positive, the prescriptive period shall commence from the time that the easement is exercised. If it is negative, then the prescriptive period will begin from the time of service of the notarized prohibition on the owner of the servient estate. Okay, now is title and prescription the only modes of acquiring easements? The answer is no. Article 622 provides that continuous non-apparent easements and discontinuous ones, whether apparent or not, may be acquired only by virtue of a title. So, as I've said, all kinds of easements may be acquired by title, but only continuous and apparent may be acquired by prescription. Now, there are other modes of acquisition of easements. These are provided under Article 623 and 624. Okay, Article 623 provides as follows. The absence of a document or proof showing the origin of an easement which cannot be acquired by prescription may be cured by a deed of recognition by the owner of the servient estate or by a final judgment. Okay, so if for example there is no title, okay, like it was not acquired through contract, it was not acquired through donation or through succession, okay, you can cure it. How? If for example the easement is already existing, okay, uh, through a deed of recognition, meaning it was executed after, okay, the title to the property was acquired. Okay, so the deed of recognition would be executed by the owner of the servient estate. Okay, or it can be through a final judgment coming from the court. So even if there is no title to the easement acquired through contract, donation, succession, if the final judgment of the court, okay, will dictate or will pronounce that the easement exists, okay, then it is also an acquisition of the easement, a mode of acquiring the easement. Okay, also, there is under Article 624, there is also an implied recognition of the easement. Okay, it states the existence of an apparent sign of easement between two estates established or maintained by the owner of both shall be considered if either of them be alienated as a title in order that the easement may continue actively and passively unless at the time of the ownership of the two estates is divided, the contrary should be provided in the title or conveyance or either of them, or the sign should be removed before the execution of the deed. This provision shall also apply in case the division of a thing owned in common by two or more persons. So it speaks of a situation wherein previously the original owner of the two adjoining lots is one and the same. However, one of the lots was alienated, okay, and there is an easement which is existing and is known to the buyer. So in this case, the knowledge, okay, by the buyer that there is an existing easement will operate to continue the easement. If he has not raised any objection, if the easement has not been removed, or if the contrary has not been provided in the deed, or if it is annotated in the title, it was not removed. Okay? In this case, there is an implied recognition of the easement. Okay? So this is another mode of acquiring an easement. Okay? Deed of recognition, final judgment, implied recognition. Okay? Uh, Rights and limitations of easements. So upon the establishment of an easement, all the rights necessary for its use are considered as granted. Because how will you be able to use the same if the other rights which are needed for its use will not be granted? Okay? The owner of the dominant estate cannot use the easement except for the benefit of the immovable originally contemplated. Neither can he exercise the easement in any other manner than that previously established. Okay? Article 623 presupposes that there is a title for the easement, but there is no document or proof showing its origin. Under Article 625, if the owner of the dominant estate is allowed to use the easement for the benefit of adjoining lands subsequently acquired, it would make the easement more onerous. So you must remember that the reason why the easement was established, the original reason, is for the benefit of the owner of the dominant estate. Now, if the owner of the dominant estate acquired other lands, okay, then it would make the easement more onerous on the part of the owner of the Serbian estate. Okay? Fernandez versus Delphine. Okay? When a person who owns two properties establishes an apparent sign of easement between them, this gives rise to a title over an easement when either of the properties is transferred to another person. We deal here, this case deals with Article 624 or the implied recognition of an easement with an apparent sign. In this case, the Fernandez spouses once owned 5 contiguous parcels of land. Now, 2 of their properties were located in front of their 3 other properties. Now, these 2 front properties provided the other properties sole access to the national highway. However, the Fernandez spouses annotated on the titles of the front properties the easement of right of way in favor of the back properties. Later on, the Delphine spouses obtained a loan and mortgaged the front properties. When they failed to pay the loan, the bank foreclosed and eventually acquired the front properties. Now, later on, it was sold to the Delphine spouses. However, the Delphine spouses refused to recognize the annotated right of way. Thus, the Fernandez spouses brought a suit for injunction. Okay. Now, in an easement of right of way, there is a portion, the servient estate, dedicated to the passage of the dominant estate's owner. It is thus a discontinuous easement used only in intervals and depending on whether a person needs to pass through another person's property. The very exercise of the servitude depends upon the acts or intervention of man, which is the very essence of discontinuous easement. As a discontinuous easement, an easement of right of way is acquired only by title. This court said a title to an easement may be acquired by an apparent sign of an easement between two estates established by the owner of both. So it is an implied recognition of an apparent easement that would serve as a title or as another mode of acquiring easements. However, the easement is created when the property is divided, when the ownership of either the dominant or the servient estate is transferred to another. When the new owner made no stipulation contrary to the apparent easement, they are deemed to have acquiesced to its continuation. So the easement becomes a burden they willingly accepted. An easement need not be annotated on the title before it may be acknowledged to exist. The existence, the existence of an easement of right of way was therefore known to the petitioners who must respect the same in spite of the fact that their title do not mention any burden or easement. It is an established principle that actual notice or knowledge is as binding as registration. So he is already estopped from denying the easement. Because he had knowledge of the same, he did not interpose any objection before he entered into the deed of sale. So the easement of right of way was not constituted when petitioners annotated it on their titles. However, when the front properties were transferred to PNB, the apparent signs of the easement, the path, and the annotations served as a title over the easement. They were aware of the easement as it was annotated on PNB's titles and on the titles issued to them. They are thus presumed to have been informed that petitioners use a portion of the front properties to access the national highway. Yet despite this knowledge, they still purchased the properties with no showing that they made any manifest objection to it at the time of transfer. Okay? We now turn to the case of Garcia versus Santos. So this case involves easements of light, air, and view, lateral support, and intermediate distances. The spouses Garcia are the registered owners of a lot. Now, at the time of the purchase of the property from the spouses Santos, the one-story house was already constructed. At the time of the acquisition, the subject property, the adjoining lot, which is owned by spouses Santos, was an idle land without any improvements until the spouses Santos started the construction of a two-story house. As such, the spouses Santos building allegedly obstructed spouses Garcia's right to light, air, and view. The construction rendered the spouses Garcia's house dark, such that they are unable to do their normal undertakings in the bedroom, living room, and other areas of the house without switching their lights. The respondents maintain that the mere presence of windows on the one-story house of the spouses Garcia in itself does not give rise to an easement by title, because they never alleged that they made a formal prohibition of the construction of a taller structure on Lot 1. An easement has been defined as a real right which burdens a thing with a prestation consisting of determinate servitudes for the exclusive enjoyment of a person who is not its owner, or of a tenement belonging to another. The legal easement, called easement of light and view, refers to an easement whereby the dominant estate enjoys the right to have a free access to light, a little air, and a view overlooking the adjoining estate. The easement of light and view has two components. The easement of light, or jus luminum, has the purpose of admitting light and a little air. An easement of view, on the other hand, has the principal purpose of affording view of full or regular windows overlooking the adjoining estate. Of course, the easement of view is broader than the easement of light because the latter is always included in the form. So these two necessarily go together because an easement of light and view requires that the owner of the servient estate shall not build to a height that will obstruct the window. So what then is an easement of light and view? Is it a positive easement or a negative? The answer is it may be both. Okay, an easement of light and view may be either positive or negative. An easement of light and view is positive if the window is situated in a party wall, while it is negative if the window is through one's own wall. It is not disputed in this case that the windows and other openings is built by the spouses Santos on Lot 1 are made in the wall of spouses Garcia. So there is no party wall. It is built on one's own wall, the dominant owner of the dominant estate. Okay, the court held that an easement of light and view in case of windows opened in one's own wall is negative. As such, it cannot be acquired by prescription except where sufficient time of possession has elapsed after the owner of the dominant estate by a formal act has prohibited the owner of the servient estate from doing something which would be lawful but for the easement. It is not disputed that the spouses Garcia never sent the spouses Santos any formal notice or notarial prohibition. So, however, does it mean that uh, the spouses Garcia do not have a right to the easement of light and view? The Supreme Court said no. Again, applying Article 624, okay, that apparent easements, okay, may be considered as equivalent to a title if the transferee had knowledge of the existence of the easement and did not register any objection to the said easement. Because easements may also be acquired through a title. So the term title does not necessarily mean a document. It refers to a juridical act sufficient to create the encumbrance. One such legal proviso refers to Article 624. According to Article 624, there arises title to an easement of light and view even in the absence of any formal act undertaken by the owner of the dominant estate if this apparent visible sign, such as the existence of door and windows, continues to remain and subsist. A one-story house laden with several windows and openings was built and the windows and openings remained open. There arose by title an easement of light and view, placing a burden on the servient estate to allow the spouses Garcia's residence unobstructed access to light and we now go to the case of Cortez versus Feud. So in this case, the property of the wife of the plaintiff has certain windows through which it receives light and air. Now, the adjoining property has commenced certain work with a view to raising the roof of the house in such a manner that one half of the windows in that said house has been covered, thus depriving the building of a large part of the air and light formerly received through the windows. Now he contends that the easement of light is positive, and therefore the period of possession for the purpose of the acquisition of prescriptive title is to begin from the date on which the enjoyment of the same commenced. On the contrary, the defendant contends that the easement is negative. The prescriptive acquisition must begin from the date of notarial prohibition. However, the Supreme Court said that the easement of light in the case of windows open in one's own wall is of a negative character and as such cannot be acquired by prescription. So the owner of the dominant estate may, by a formal act, have prohibited the owner of the servient estate from doing something which would be lawful for him to do were it not for the easement. So for the prescriptive acquisition of the former, the time must begin as we have seen from the opening of the window in the neighbor's wall. As to the second, the time commences from the date in which he was prevented from raising his house. The easement of light, which is the object of this litigation, is of a negative character and therefore pertains to the class which cannot be acquired by prescription. The plaintiff not having executed any formal act of opposition to the right of the owner, nor he has also not acquired, nor could he acquire by prescription such easement of light, no matter how long a time might have elapsed, because of the absence of a notarial prohibition. Now, what are the rights and obligations of the owners of both the dominant and the servient estates? The owner of the dominant estate may make at his own expense on the servient estate any works that is necessary for the use and preservation of the servitude. For this purpose, he shall notify the owner of the servient estate and shall choose the most convenient time and manner so as to cause the least inconvenience to the owner of the servient estate. Okay? First and foremost, among the rights of the owner of the dominant estate is the right to use the easement, because it is for his benefit that the said easement was established. So, it is also his right to make works necessary for the preservation of the easement. Okay, this is obligation to notify the owner of the said works and to schedule it at a time which is most convenient to the owner of the servient estate. Okay? Should there be several dominant estates, the owners of all of them shall be obliged to contribute to the expenses. Okay? Because it was established for their own mutual benefit. The owner, on the other hand, the owner of the servient estate, cannot impair the use of the servient. Again, easement is a limitation on the rights of ownership of the servient estate, and therefore he has the obligation to respect the easement and not to build or construct anything which would impair the use of the servitude. However, if by reason of the place originally assigned or of the manner established for the use of the easement, the same should become very inconvenient to the owner of the servient estate or should prevent him from making any important works, repairs, or improvement, it may be changed at his expense provided he offers another place or manner equally convenient and in such a way that no injury is caused to the owner of the servient estate. So the owner of the the servient estate retains the option to change the place of the easement, but not to refuse uh, the use of the easement. Okay, he can change the place of the easement provided he does so at his expense and he offers another way which which will not cause injury or inconvenience to the owner of the dominant estate. Again, one of the rights also of the servient estate is that he retains ownership of the portion on which the easement is established and may use the same in such a manner as not to affect the exercise of the lease. Okay? What are the rights and obligations of the owner of the dominant estate? Again, to use the easement. Okay, to use and enjoy the easement. That is his primary right as owner of the dominant estate. Second, to make works, necessary works for the preservation of things. What are the obligations of the owner of the dominant estate? To shoulder the expenses needed for the works on the preservation of the easement because the easement was for their benefit. Okay, so it is imperative that they should also shoulder the expenses needed for its preservation. Okay, second, not to alter or render the easement more burdensome. Okay, and third is to notify the owner of the servient estate so as to undertake the works in the most convenient time. So whenever there are works which are needed for the preservation of the estate, he has the obligation to inform the owner of the servient estate so as to schedule the works in a time which is most convenient to the owner of the servient estate. What are the rights as well as the obligations of the owner of the servient estate? With respect to rights of the owner of the servient estate, he retains ownership of the land on which the easement is established. Okay, he can use it because he is its owner, provided that it would not affect the use of the easement. Okay, and third is he can change the location of the easement at his expense and provided no injury is caused to the owner of the dominant estate. Okay, now what are the obligations of the owner of the servient estate? He has the obligation to preserve and not to impair the use of the easement. And he must allow the owner of the dominant estate to make the necessary works for the preservation of the easement. Okay, we now go to the case of Mercader versus Bardilas. The issue in this case concerns the right of way between the owners of three parcels of land. Clarita Village Association erected a concrete perimeter fence to close the exit point at the right of way of the spouses Bardilas to the existing road within Clarita Village. Now, spouses Mercader allege that they were the lawful owners of adjoining lots, that they retained the ownership of the portion of the property on which the easement was established. And they also contend that the non-user of the easement has extinguished it. Okay, however, the Supreme Court ruled that the petitioner's claim cannot be sustained, that they acquired their right to the road right of way by title. Easement, it gives the holder of the easement an incorporeal interest on the land but grants no title thereto. Therefore, an acknowledgement of the easement is an admission that the property belongs to another. An encumbrance subject to 3 meters wide right of way was annotated on the title. As the owners of the Serbian estate, the spouses Bardilas retained ownership of the road right-of-way, even assuming that said encumbrance was for the benefit of another lot, the lot of spouses Mercader, with the right-of-way belonging to them as owners of the burdened property. The spouses Bardilas remained entitled to avail themselves of all the attributes of ownership, specifically jus utendi, jus provendi, jus abutendi, jus disponendi, and jus vindicanti. Okay, so Article 428 recognizes that the owner has the right to enjoy and dispose of a thing without other limitations than those established by law. We now go to the different modes of extinguishment of the easement. First among these modes is merger. When we speak of merger, okay, the ownership of both the Serbian as well as the dominant estate is one and the same. They are merged in one and the same person. Because if you are the owner of both the dominant as well as the Serbian estate, when you exercise your right to use and enjoy the easement, you're exercising it not as an easement, but an exercise of your right of ownership. The right to use and the right to enjoy the property as an owner and not as a limitation on your right of ownership. So the easement is extinguished. Non-user for 10 years. With respect to discontinuous easements, this period shall be computed from the day on which they cease to be used, and with respect to continuous easements, from the day on which an act contrary to the same took place. So if you have not used the easement for a period of 10 years, then the easement will be extinguished. Okay, and number 3, when either or both estates fall into such condition that the easement cannot be used. In other words, loss of the property, but it shall be revived if the subsequent condition of the estate should again permit its use, unless when the use becomes possible, sufficient time for prescription has already elapsed. Okay, expiration of the term of the easement, because in the title granting the easement, the parties may have stipulated a term or a period or a condition. Okay, the fulfillment of the condition if the easement is temporary or condition. Okay, fifth, by the renunciation of the owner of the dominant estate. If, for example, the dominant estate has acquired a lot which gave him access to the road, okay, then the owner of the dominant estate may renounce the easement by the redemption agreed upon between the owners of the dominant as well as the Serbian estates. Okay? For merger to extinguish easements, the owner of both the dominant and Serbian estates must be one and the same. If the easements can be acquired through prescription, they can also be lost through non-use for a period of 10 years. The non-use must be voluntary and not due to a fortuitous event. If the easement becomes impossible to use due to man-made or fortuitous causes, the easement is suspended and resumes when use is possible unless prescription sets in. Okay? Renunciation, that is a waiver on the part of the owner of the dominant estate. It must be express and clear. And redemption, it must be by virtue of a contract which consists of payment of an amount of money or doing of an act. Okay? The case of Taniedo versus Bernard. Cardenas was the owner of 2 contiguous parcels of land. Okay? On one parcel, an apartment building was constructed. There is a 4-door apartment, and on another lot, there is a septic tank for the common use of the occupants of the building as well as the apartment. Cardenas, however, sold one of the lots to the spouse's sim. Now, Taniedo offered to redeem the property from the spouse's sim, but the spouse's sim refused. So what the spouse's sim did was to block the sewage pipe connecting the building to the septic tank. So it was the spouse's sim, the lot of the spouse's sim, upon which the septic tank was located. Okay. So does the alienation of properties originally belonging to one owner, okay, and then now it is alienated to two different owners, does it extinguish the easement? So in this case, the Supreme Court said alienation of the dominant and servient estates to different persons is not one of the grounds for the extinguishment of an easement. On the contrary, use of the easement is continued by operation of law. No statement abolishing or extinguishing the easement of drainage was mentioned in the deed of sale. Hence, the use of the septic tank is continued by operation of law. The spouses in the new owners of the servient estate cannot impair in any manner the use of the servitude. Okay, we have the case of Castro versus Esperanza. In this case, petitioners are the owners of two lots. Okay, on the southwest part of their lot lies a footpath. Respondents and the owners of the neighboring lots use the footpath as ingress and egress to the national highway. Now, the petitioners constructed an interlinked wire fence and closed off the footpath. So the respondents used the dry creek as a way in and out of their property for a long time. Now, the petitioners reiterate that although the footpath has a separate title, it is intended for their benefit and not for the benefit of respondents who already had a dry creek as their means of access to the highway. Being a voluntary easement, control over the footpath remained with Nestor Reluya, who is the former owner. And after his death, control over the footpath had been transferred to them as his successor in interest. Now, do the respondents have the right to use the footpath as ingress and egress, and the requisite standing as well to pray that petitioners remove the fence that they constructed to close off the footpath? So the opening of an adequate outlet to a highway can extinguish only legal or compulsory easements, not voluntary easements. The fact that an easement by grant may have also qualified as an easement of necessity does not detract from its permanency as a property right, which survives the termination of the necessity. The footpath was a voluntary easement constituted by Nestor Reluya, and this fact was confirmed by the case. The separate title to the footpath was retained by Nestor Reluya and later on passed on to his heirs after his death. Hence, although the dry creek had been turned into a gravel road that gives access to the national highway, the footpath has not lost its nature as a voluntary easement, which benefits respondents and third persons. So, the thing to remember in the case of Castro is that with respect to voluntary is the fact that um, an access to the highway has already been obtained by the owners of the dominant estate. It will not result in the extinguishment of the easement because it is a voluntary easement or an easement by grant. Okay? We now go to Articles 632 and 633, referring to the use by a co-owner. The form or manner of using the easement may prescribe as the easement itself and in the same way. If the dominant estate belongs to several persons in common, the use of the easement by any one of them prevents prescription with respect to the others. The possession and use by any one of the co-owners benefits all the other co-owners and prevents prescription from running. Remember, use of the easement by one of the co-owners. It prevents prescription. It inures to the benefit of all the other co-owners. It is a necessary consequence of the nature of easements because an easement is indivisible. So the use of one is sufficient to toll the running of the prescriptive period. Okay? Let us now go to legal easements or those easements which are imposed by law. Easements imposed by law have for their object either public use or the interest of private persons. So all matters concerning easement established for public or communal use shall be governed by the special laws and regulations, and in the absence by the provisions of this title. Okay? Easements established by law in the interest of private persons or for private use shall be governed by the provisions of this title without prejudice to general or local laws and ordinances. These easements may be modified by agreement of the parties whenever the law does not prohibit it or no injury is suffered by third persons. Okay? First kind of legal easement is easements relating to waters. Okay. Article 637, okay, establishes easements of the flow of water from the higher to the lower estates. It states that lower estates are obliged to receive the waters which naturally and without the intervention of man descend from the higher estates, as well as the stones or earth which they carry with them. So the owner of the lower estate cannot construct works which will impede this easement, neither can the owner of the higher estate make works which will increase the burden. Remember the previous case of Lunod versus Meneses? Okay, this refers to the easement of the lower estates receiving waters from the higher estates. Okay, Article 638, the banks of rivers and streams, even in the case they are of private ownership, are subject throughout their entire length and within a zone of 3 meters along their margins to the easement of public use in the general interest of navigation, floatage, fishing, and salvage. So within a zone of 3 meters, the banks of rivers and streams are subject to the easement of navigation, fishing, floatage, and salvage. Estates adjoining the banks of navigable or floatable rivers are furthermore subject to the easement of towpath for the exclusive service of river navigation and floatage. Okay? If it is necessary to occupy lands of private ownership, proper indemnity shall first pay. The easement of abutment of dam. Okay, Article 639 tells us that when for the diversion or taking of water from a river or a brook, or for the use of any other continuous or discontinuous stream, it is necessary to build a dam. And the person who is to construct it is not the owner of the bank or lands which must support it. He may establish the easement of abutment of dam after payment of indemnity. Okay? There is also the easement of drawing water for watering animals. It can be imposed for public use in favor of a town or village. Okay, easements for drawing water or for watering animals carry with them the obligation of the owners of the servient estates to allow passage to persons and animals to the place where such easements are to be used, and the indemnity shall include this service. Okay, another easement relating to waters is easement of aqueduct. Okay, any person who may wish to use upon his own estate any water of which he can dispose shall have the right to make it flow through the intervening estates, with the obligation to indemnify their owners as well as the owners of the lower estate upon which the waters may filter or descend. Okay. Now, what are the requisites for Article 643 or the easement of aqueduct to apply? Okay. First, he must prove that he can dispose of the water and that it is sufficient for the use for which it is intended. Okay. Number two, to show that the proposed right of way is the most convenient and the least onerous to third person. And third, to indemnify the owner of the servient estate in the manner determined by laws and regulations. Normally, easement of aqueduct is used for agricultural purposes. Okay, to make the waters flow through intervening estates in order to reach the dominant estate. So the easement of aqueduct for private interest cannot be imposed on buildings, courtyards, annexes, courthouses, or on orchards or gardens already existing. The easement of aqueduct does not prevent the owner of the servient estate from closing or fencing it or from building over the aqueduct in such a manner as not to cause the latter any damage or render necessary repairs and cleanings if possible. Because the owner of the uh, estate, the owner of the servient estate retains ownership over the property. So he can build over the easement of aqueduct provided that he will not impair the use of the easement. Okay, for legal purposes, easement of aqueduct shall be considered as continuous and apparent. Although in reality, it is really discontinuous because the flow of water is not incessant. And it is non-apparent because it is buried underground. But for purposes of law, it is considered as continuous and apparent. So it may be acquired by prescription. Okay? Okay, another servitude of waters is under Article 647. One who for the purpose of irrigating or improving his estate has to construct a stop clock or sluice gate in the bed of the stream from which the water is to be taken, may demand that the owners of the banks permit its construction. Okay? We now go to the case of Balisno versus Adriano. The plaintiff is the owner and possessor of a parcel of land. And that land is planted to watermelon, peanuts, corn, tobacco, and other vegetables. The land adjoins that of Apeli Adriano on the bank of the Pampanga River. Now, at the time of the sale of the land to Balisno, the land was irrigated by water from the Pampanga River through a canal traversing the Apeli's land. However, the Apeli leveled a portion of the irrigation canal so that the appellant was deprived of irrigation water. Now, the existence of the irrigation canal for the passage of water from the Pampanga River prior to and at the time of the sale was equivalent to a title for the vendee of the land to continue using it as provided in Article 624. So the deed of sale in favor of Balisno included the conveyance and transfer of the water rights and improvements. The water right was the primary consideration for his purchase of Honorata's property, for without it, the property would be unproductive. An easement of water in favor of the appellant has been established. He is entitled to enjoy it free from obstruction, disturbance, or wrongful interference. Again, Article 624 was applied, okay, in which the uh, apparent sign of the canal, okay, was taken into consideration and the easement was uh, existing. It was there. It was seen by the vendee, but the vendee did not object to the said easement. Thus, it is deemed to continue and it is considered as an implied recognition of the easement. Okay. Another case involving waters, Salazar versus Gutierrez. In this case, before the present controversy arose, Lot 436 and some of the surrounding estates, including Lot 433, were irrigated with water from Sapang Puyo, a public stream flowing through a dike. It was with the water flowing through this canal that Lot 436 used to be irrigated. Now, the respondent Mendoza, a lessee of Lot 433, demolished the canal, thereby stopping the flow of water and depriving Salazar's Lot 436 of irrigation facilities. Now, what is the nature of the easement of aqueduct? If voluntary, the easement was extinguished upon the registration of Lot 433. So, in this case, the original registration, the original registered owner allowed the easement to continue in spite of such non-registration. The least that it can be said is that he either recognized its existence as a compulsory servitude on his estate or voluntarily agreed to its establishment and continuance. Not only was he aware of the existence of the easement when he inherited the property, but he likewise allowed it to continue for 26 years after he acquired title. He is bound by the act of his predecessor as well as his own. Okay? Now we go to easement of right of way. Easement of right of way may be either legal. So if all the requisites established by law, they are met, okay, then you can compel the owner of the servient estate to give you a right. Or it may be voluntary, meaning by title, by agreement of the parties. So, as long as the owner of the servient estate agrees to the grant of a right of way to the dominant estate, and the parties have agreed to it, then that is a voluntary easement of right of way. Okay? Article 649 tells us the owner of any person who by virtue of a real right may cultivate or use any immovable which is surrounded by other immovables pertaining to other persons and without adequate outlet to a public highway is entitled to demand a right of way through the neighboring estates after payment of proper indemnity. If should this easement be established in such a manner that its use may be continuous for all the needs of the dominant estate, establishing a permanent passage, the indemnity shall consist of the value of the land occupied and the amount of the damage caused to the servient estate. In case the right of way is limited to the necessary passage for the cultivation of the estate surrounded by others, and for the gathering of crops through the servient estate without a permanent right of way, the indemnity shall consist in the payment of the damage caused by the encumbrance. This easement is not compulsory if the isolation of the immovable is due to the proprietor's own acts. Okay? Article 650 tells us of the least prejudicial and most convenient. The easement of right of way shall be established at the point least prejudicial to the servient estate and insofar as consistent with this rule where the distance from the dominant estate to the public highway may be the shortest. Okay? But remember that in this case, least prejudicial prevails over shortest distance. So, least prejudicial takes the utmost priority. It must be at a point where the right of way is least prejudicial to the owner of the servient estate. How about the width of the easement? Okay, who determines the width of the easement? So the width of the easement of right of way shall be that which is sufficient for the needs of the dominant estate and may accordingly be changed from time to time. So if previously the right of way is merely for pedestrians or only a footpath, it may be increased to accommodate vehicles if the needs of the dominant estate dictates that a vehicle should be allowed to pass through the right of way. Okay, Article 652 tells us whenever a piece of land acquired by sale, exchange, or partition is surrounded by other estates of the vendor, exchanger, or co-owner, he shall be obliged to grant a right of way without indemnity. In case of simple donation, the donor shall be indemnified by the donee for the establishment of the right of way. Okay. In the case of the preceding article, if it is the land of the grantor that becomes isolated, he may demand a right of way after paying indemnity. However, the donor shall not be liable for indemnity. Okay. Extinguishment of right of way. If the right of way is permanent, the necessary repair shall be made by the owner of the dominant estate. A proportionate share of the taxes shall be reimbursed by the said owner to the proprietor of the subject estate. Okay? If the right of way is granted to a surrounded estate, ceases to be necessary because its owner has joined it to another abutting on a public road. The owner of the servient estate may demand that the easement be extinguished, returning what he may have received by way of indemnity. The same rule shall be applied in case a new road is opened, giving access to the isolated estate. In both cases, the public highway must substantially meet the needs of the dominant estate. Remember, the extinguishment of the easement is not automatic, meaning the owner of the servient estate must demand the closure of the right of way. Okay? And as I've said, if it is a voluntary easement and not a legal easement, okay, this provision does not apply. Okay, why? Because it is one which is agreed upon by the parties. And unless there is a waiver or there is a renunciation executed by the owner of the dominant estate, the voluntary easement of right of way subsists, even if a new road has been opened, giving the owner of the dominant estate access to the highway. This will only apply in case of compulsory or legal easements of right of way, in which case the owner of the servient estate may demand that the right of way be closed. But as I've said, it is not automatic. If after the demand, the owner of the dominant estate refuses, then he has to go to court and he has to prove that accessibility has already been obtained by the owner of the dominant estate. So there is no need for the right of way. Okay. Let us now go to special right of way easement. Okay. If it is necessary for the construction, repair, improvement, alteration, or beautification of a building, to carry materials through the estate of another, or to raise scaffoldings or other objects, the owner of the estate shall be obliged to permit the said act. So these are special right of way which is temporary in nature while the building is being constructed or repaired. Easements of right of way for the passage of livestock, known as animal path, animal trail, or any other, and those for water place, resting places, and animal folds shall be governed by ordinances, and in the absence thereof by the usages and customs of the place. The animal path shall not exceed the width of 75 meters, and the animal trail that of 37 meters and 50 centimeters. Whenever it is necessary to establish a compulsory easement of right of way or for a watering place for animals, the provisions of this section and those of Article 640 and 641 shall be observed. Okay, right of way easement defined. It is a right granted by law to the owners of estate which is surrounded by other estates belonging to other persons and without adequate outlet to the public highway to demand passageway through neighboring estates after payment of the proper indemnity. What are the requisites of a compulsory or legal right-of-way easement. First, the claimant must be the owner of an enclosed immovable or one with real rights such as the use of proctory or registered deed. In other words, you are bounded by land. You have no access to the highway or to the public road. Okay? There must be no adequate outlet to the public highway, and the right of way must be absolutely necessary for the enjoyment of this property. The isolation must not be due to the claimant's own. Okay, so you must not be the reason why your property had no access. The easement must be established at the point least prejudicial to the servient estate, shortest distance and least damage with preference to the latter. And there must be payment of proper indemnity consisting of the value of the land occupied plus damages. We now go to the case of Villanueva versus Velasco. Villanueva is the registered owner of a parcel of land previously owned by the spouses Gabriel. When Villanueva bought the land, there was a small house on the southeastern portion, occupying 1 meter of the 2 meter wide easement of right of way that the Gabriel spouses granted to the Espinolas. So the easement in the case at bar is both voluntary and legal. The settled rule is that the needs of the dominant estate determine the width of the easement. Hence, the petitioner should demolish the small house on the easement, obstructing the entry of private respondent cement mixer and motor vehicle. In legal easement, the servient estate is bound to provide the dominant estate ingress from and egress to the public highway. We note that the subject easement originally was voluntarily constituted by agreement between the Gabriels and the Espinolas. The easement in this case is both an easement by grant or a voluntary easement and an easement by necessity or a legal easement. A legal easement is one which is mandated by law, constituted for public use or for private interest, and becomes a continuing property right. As a compulsory easement, it is inseparable from the estate to which it belongs. It is settled that the needs of the dominant estate determine the width of the easement. Conformably then, petitioner should demolish whatever edifice obstructs the easement in view of the needs of the private respondent's estate. It is in the nature of legal easement that the servient estate is legally bound to provide the dominant estate ingress from and egress to the public highway. Okay, we now go to the case of Dichoso versus Marcos. Petitioners filed a complaint for easement of right of way against Marcos. Petitioners had no access to a public road to and from their property. They claim to have used a portion of Lot 1 in accessing the road. However, respondent blocked the passageway with piles of sand. Though petitioners have been granted another passageway by the spouses Arce, the owners of another adjacent lot. Now, petitioners' claim of right of way is only due to expediency and not necessity. It must be stressed that an easement involves an abnormal restriction on the property rights of the servient owner and is regarded as a charge or encumbrance on the servient estate. The owner of the dominant estate to establish by clear and convincing evidence the presence of all the preconditions before his claim for easement of right of way may be granted. However, the petitioners failed in this regard. Remember that for easement of right of way, legal or compulsory easement of right of way to be granted, it is imperative that access to the public highway must not exist. Okay, clearly there is an existing outlet to and from the public road. Petitioners claim that the outlet is longer and circuitous, and they have to pass through other lots owned by different owners. before they could get to the highway, we find petitioners' concept of what is adequate outlet a complete disregard of the doctrine that in order to justify the imposition of an easement of right of way, there must be real, not fictitious or artificial necessity for it. Mere convenience for the dominant estate is not what is required by law as the basis of setting up a compulsory easement. The convenience of the dominant estate has never been the gauge for the grant of compulsory right of way. The true standard for the grant of legal right is adequacy. Hence, when there is already an existing adequate outlet from the dominant estate to a public highway, for one reason or another, can be inconvenient, the need to open up another servitude is unjustified. Another case is Talisay Silay versus Court of First Instance. In this case, the petitioner, Talisay Silay, had an existing railway track. However, the landowners, the railway track, the lots of which were owned by the farmers. So they refused to extend the 50-year contractual right of way granted to the Central Railway Complex. The Central was granted the right to construct and maintain railroad lines traversing the planters' properties for the hauling of sugarcane from the various plantations in the mill district to the mill site. Now, um, is Talisay Silay Milling entitled to the right of way? Okay, a legal or compulsory right of way. Okay, where the requisites established by law met by Talisay Silay. The complaint clearly shows that the Central, even as it assumes the role of a dominant estate, wants a railway access to the fields of its planters to be able to haul the latter sugarcane to the milling site. It does not seek access to a public highway. So the first and primary requisite, which is to provide the dominant estate access to a public highway, was not met because the purpose of Talisay Silay is to gain access from the field to the milling site. Okay? So it is not to give him access to the public highway. So the first requisite is obviously lacking, so legal or compulsory right of way cannot be granted. Okay? Cristobal versus Court of Appeals. Petitioners own a house and lot. Now, Ledesma is the owner of a subdivision which once included the disputed residential lot. The said lots were originally part of a private road owned exclusively by Ledesma. Now, Road Lot 2 was converted into residential lots which was sold to Pasione. Now, when the Pasione spouses who intended to build a house on Lot 1 visited the property, they found out that the lot was occupied by a squatter named Geronimo, and a portion was being used as a passageway by petitioners to and from Visayas Avenue. Okay, so the first element of a compulsory easement of right of way that the dominant estate is surrounded by other immovables and has no adequate outlet to a public highway is clearly absent. Okay, an outlet already exists, which is a pathwalk located at the left side of petitioner's property and which is connected to a private road. Okay, in order to justify the imposition of an easement of right of way, there must be a real, not fictitious or artificial necessity for it. Mere convenience for the dominant estate is not what is required by law as the basis for setting up a compulsory. So it is incumbent upon the owner of the dominant estate to establish by clear and convincing evidence the presence of all the preconditions for his claim of easement of right of way. However, petitioners failed in this regard. So we now go to the case of Santa Maria versus Court of Appeals. In this case, spouses Fajardo are the registered owners of a parcel of land entirely surrounded by lots belonging to different owners. One of them is spouses Santa Maria. Now, the spouses Fajardo filed a complaint for the establishment of an easement of right of way. Okay? Uh, Petitioners in their answer allege that the granting of the easement would cause them great damage and inconvenience, and that there is another access to the main road. Okay. As to the daang tao at the back of private respondent's property, it must be stressed that the width of the easement shall be that which is sufficient for the needs of the dominant estate and may be changed from time to time. Therefore, the needs of the dominant estate determine the width of the easement. Okay. Encarnacion versus Court of Appeals. Again, this refers to the width of the easement to be determined by the needs of the dominant estate. Encarnacion and the heirs of Maxine are the owners of two adjacent estates. The private respondents, the Magsinos, constructed a fence around the Serbian estate, a road path measuring 25 meters long and about a meter wide, was constituted to provide access to the highway. At that time, the petitioner started his plant nursery business on his land where he also had his residence. Now, petitioner was able to buy an owner-type jeep, which he could use for transporting his plants. However, the jeep could not pass through the road path. So they instituted a case to seek the issuance of a compulsory easement of right of way of at least 2 meters, because what was provided to them only is a 1 meter wide right of way. Okay? To Article 651 provides that the width of the easement shall be that which is sufficient for the needs of the dominant estate. This is taken to mean that under the law, it is the needs of the dominant property which ultimately determine the width of the passage, and these needs may vary from time to time. To force the petitioner to leave his jeepney in the highway, exposed to the elements and to the risk of theft, simply because it could not pass through the pathway is sheer pig-headedness on the part of the Serbian estate and can only be counterproductive for all the people concerned. Petitioner should not be denied a passageway wide enough to accommodate his jeepney, since that is a reasonable and necessary aspect of a planned nursery business. Okay, we now turn to the case of Costa Bellia versus Court of Appeal. The issue in this case is whether or not the private respondents had acquired an easement of right of way in the form of a passageway on the petitioner's property. Petitioner owns the real properties in which it had constructed a resort and a hotel. So the private respondents, on the other hand, are the owners of adjoining properties. Okay. Before the petitioner began the construction of the hotel, they passed through a passageway which traversed the petitioner's property. However, sometime in 1981, the petitioner closed the passageway when it began the construction of the hotel. So the petitioner fenced its property, thus closing even the alternative passageway and preventing the private respondents from traversing any part of it. To justify the imposition of an easement of right of way, there must be a real, not a fictitious or artificial necessity for it. Further, the private respondents failed to indicate in their complaint or even to manifest during the trial that they were willing to indemnify fully the petitioner for the right of way to be established over its property. Finally, the private respondents failed to allege, much more introduce any evidence that the passageway they seek to be reopened is at a point least prejudicial to the petition. There must be a real necessity and not a mere convenience for the dominant estate. Hence, if there is an existing outlet to the highway, the dominant estate cannot demand the right of way, although the same may not be convenient. Of course, the question of when a particular passage may be said to be adequate depends on the circumstances of the case. The estate itself need not be totally landlocked. What is important is whether or not a right of way is necessary to fill a reasonable need, therefore, by the owner. So also, while an existing right of way may have proved adequate at the start, the dominant owner's needs may have changed since then. Okay? Another case, Bapsi versus Obias. Isodeco constructed a road which was used by in the hauling and transporting of sugarcane to and from its mill sites. The respondents barricaded the disputed road. Now, Bisodeco acquired a right of way over the properties of the landowners. That was their contention. Okay. Uh, In order for petitioner to acquire the disputed road as an easement of right of way, it was incumbent upon the petitioner to show its right either by title or by an agreement with the owners of the land that the said road traversed. So again, the Supreme Court, guided by the case of Bogong Medellin, this court discussed the discontinuous nature of an easement. So the easement of right of way is considered discontinuous because it is exercised only if a person passes or sets foot on somebody else's land. Like a road for the passage of vehicles, an easement of right of way of railroad tracks is discontinuous because the right is exercised only if and when a train operated by a person passes over another's property. In other words, the very exercise of the servitude depends upon the act of man. It is not the presence of an apparent sign or physical indication showing the existence of an easement, but rather the manner of exercise that categorizes the easement into continuous or discontinuous. The road in dispute is a discontinuous easement, notwithstanding that the same may be apparent. Hence, even if the road has been improved and maintained over a number of years, it will not change its discontinuous nature. Okay? We now go to the case of Vargas versus Santa Lucia. In this case, spouses Vargas owns a parcel of land, and they bought another parcel of land in Vista Real, which is adjacent to their outside lot. Now, the spouses demanded from Vista Real a right of way from the outside lot to their VRC lot. Now, whether the spouses are entitled to a right of way from their outside lot through VRC, compulsory or legal. Okay. Although the spouses were able to prove that the outside lot is indeed surrounded by other immovables, they failed to prove that it has no adequate outlet to the public highway. If an isolated lot may be given access to a public road without imposing an easement, the courts will not grant the easement. The spouse's failure to submit any evidence on the physical and geographical condition of the three other lots surrounding the outside lot also prevented them from establishing compliance with the fourth requisite. The trial court could not have ruled on the spouse's allegation that the streets inside BRC are the shortest route and only available access from the outside lot to Commonwealth Avenue, precisely because there is no data on the accessibility of the three other lots with which the trial court could compare and contrast the adequacy of the proposed route through BRC. Okay, so we're through with easements. We now go to easement of party wall. Okay, Article 658 tells us that the easement of party wall shall be governed by the provisions of this title, local ordinances, and customs. and by the rules of co-ownership. What is a party wall? A party wall is a common wall which separates two estates built by agreement at the dividing line such that it occupies a portion of both estates in equal parts. So it is necessarily a co-ownership, okay? Because one half of the wall belongs to one owner, the other half of the wall belongs to the adjoining owner. So easement of party wall, the rights and obligations arising from the existence and common enjoyment of a wall, fence, enclosures, or hedges by the owners of adjoining buildings and estates. Okay? Article 655 speaks of when a party wall exists. So the existence of an easement of party wall is presumed unless there is a title or exterior sign or proof to the contrary. In dividing walls of adjoining buildings up to the point of common elevation, in dividing walls of gardens or yards situated in cities or towns or in rural communities, in fences, walls, and live hedges dividing rural lands. It is understood that there is an exterior sign contrary to. So meaning, if you see any of these exterior signs, it would negate the existence of a party wall. Okay? Whenever in the dividing wall of buildings, there is a window or opening, whenever the dividing wall is on one side, straight and plumb on all its basement, and the other, it has similar conditions on the upper part, but the lower part slants or projects upward. Whenever the entire wall is built within the boundaries of one of the estates, whenever the dividing wall bears the burden of the binding beams, floors, and roof frame of one of the buildings, but not those of the others, whenever the dividing wall between courtyards, gardens, and tenements is constructed in such a way that the coping sheds the water upon only one of the estates, whenever the dividing wall being built of masonry has stepping stones which at certain intervals project from the surface on one side only, but not on the other, whenever the lands enclosed by fences or live hedges adjoin others which are not enclosed, in all these cases the ownership of the walls, fences, and hedges shall be deemed to belong exclusively to the owner of the property or tenement which has in its favor the presumption based on any of these signs. We now go to ditches or drains. Under Article 661, ditches or drains open between two estates are also presumed as common to both if there is no title or sign showing the contrary. Now, there is a sign to the contrary to the part ownership whenever the earth or dirt removed to open the ditch or to clean it is only on one side, in which case the ownership of the ditch shall belong exclusively to the owner of the land having this exterior sign. The cost of repairs and constructions of party walls and maintenance of fences, live hedges, ditches, and drains shall be borne by all the owners of the lands or tenements having the party wall in their favor. Okay? What if there is a need to demolish or to increase the height of the party wall? If the owner of a building supported by a party wall desires to demolish the building, he may also renounce his part ownership of the wall, but the cost of all repairs and works necessary to prevent any damage which the demolition may cause to the party wall shall be borne by him. Okay? Every owner may also increase the height of the party wall, doing so at his expense and paying for any damage which may be caused by the work, even though such damage is only temporary. The expenses of maintaining the wall in the part newly raised shall also be paid by him. Okay? A party wall cannot bear the increased height. The owner desiring to raise it shall be obliged to reconstruct it at his expense. And under Article 666, every part owner of a party wall may use it in proportion to the right he may have in the co-ownership without interfering with the common and respective uses by the other co-owners. Okay, let us now go to another legal easement of light and okay. No part owner may, without the consent of the others, open through the party wall any window or aperture of any type. Okay, so again, when a window is constructed on a party wall, it is a positive. Again, what is an easement of light? It is the right to admit light from a neighboring estate by virtue of the opening of a window. Easement of view. It is the right to make openings or windows to enjoy view through the estate of another and to prevent constructions which would obstruct the view or make it difficult. So the period of prescription for the acquisition of an easement of light and view shall be counted from the time of the opening of a window if it is through a party wall. Why? Because the consent of the other party is needed. Okay, so it is deemed as a positive easement, or from the time of the formal prohibition upon the proprietor of the adjoining land if the window is through a wall on the dominant estate. Okay, another uh, legal easement is distances between walls. Article 670 tells us that no windows, apertures, balconies, or similar projections which afford a direct view upon or towards an adjoining land can be made without leaving a distance of 2 meters between the wall in which they are made and such contiguous property. Neither can side or oblique views towards such coterminous property be had unless there is a distance of 60 centimeters. So remember, distances between walls or windows, if it is a direct view, it should have a distance of 2 meters. If it is a side or oblique view, it should be a distance of 60 centimeters. The non-observance of these distances does not give rise to prescription. Okay? Openings to admit light. When the distances in Article 670 are not observed, the owner of a wall which is not a party wall adjoining a tenement can make it in it openings to admit light at the height of the ceiling joist or immediately under the ceiling and the size of 30 centimeters square, and in every case with an iron grating embedded in the wall and with a wire screen. So if you cannot meet the 3 centimeters and the 60 centimeters requirement, then you can have just an opening to admit light. They immediately under the sea. Nevertheless, the owner of the tenement or property adjoining the wall in which the openings are made can close them should he acquire part ownership thereof. Okay? Easement of direct view. Whenever by any title a right has been acquired to have direct views, balconies, or belvederes overlooking an adjoining property, the owner of the servient estate cannot build at less than a distance of 3 meters to be measured. The provisions in Article 670 are not applicable to buildings separated by a public highway or alley, which is not less than 3 meters wide, subject to special regulations and ordinances. Okay, another legal easement is the easement of drainage. Article 674 tells us that the owner of a building shall be obliged to construct its roof or covering in such a manner that the rainwater will not shall fall on his own land or on a street or a public place and not on the land of his neighbor. So it is actually an obligation. It is not an easement, but an obligation on the part of the property owner to ensure that the rainwater will fall to his own land or to a public street or a public place and not on the land of the state. Okay? The owner of a tenement or a piece of land subject to the easement of receiving water falling from roofs may build in such a manner as to receive the water upon his own roof or to give it another outlet in accordance with local ordinances or customs. Easement of outlet to rainwater. Whenever the yard or court of a house is surrounded by other houses, and it is not possible to give an outlet through the house itself to the rainwater, the establishment of an easement of drainage can be demanded, giving an outlet to the water at the point of the contiguous lands or tenements where its egress may be the easiest, and establishing a conduit for the drainage in such a manner as to cause the least damage to the servient estate after payment of proper indemnity. We now go to the legal easement of intermediate distances and works for certain constructions and plantings. No construction can be built or plantings made near fortified places or fortresses without compliance with the conditions in special laws, ordinances, and regulations. This is an easement in favor of the state to protect national security. Also, no person shall build any aqueduct, well, sewer, furnace, forge, chimney, stable, depository of corrosive substances, machinery, or factory, which by reason of its nature is dangerous or noxious, without observing the distances prescribed by regulations and customs. Okay? Negative easement for planting trees. Again, this is another legal easement. No tree shall be planted near a tenement or a piece of land belonging to another except at a distance authorized by ordinances or custom, and in the absence thereof, a distance of at least 2 meters from the dividing line of the estate in case of tall trees, and at a distance of at least 50 centimeters if shrubs or small trees are planted. So if you have an adjoining estate, okay, the trees, tall trees that should be planted should be at least 2 meters from the dividing line. Okay? And in case of shrubs, it should be 50 centimeters. What if the required distances are not observed? Every landowner shall have a right to demand that the trees planted at a shorter distance from his land be uprooted. You acquire the right to demand that the said trees be uprooted. If the branches of any tree should extend over a neighboring estate, tenement, garden, or yard, the owner of the latter shall have the right to demand that they be cut off insofar as they may spread over his property. And if it is the roots of a neighboring tree which should penetrate into the land of another, the latter may cut them off himself within his property. So if there are branches or if there are roots which penetrate within the adjoining land, then you also have the right to demand that they be cut. Roots naturally falling upon adjacent land belong to the owner of said land. Remember the word naturally. So you cannot pick up the fruits that penetrate your own land or extend through your land as to fall naturally. But you have the right to cut the branches. Okay, if they extend through your land. So if the branches have roots within them, then you can always argue that you are cutting the branches, not the roots. Okay, now we also have the easement against nuisance. Every building or piece of land is subject to the easement, which prohibits the proprietor or possessor from committing nuisance through noise, jarring, offensive odor, smoke, heat, dust, water, glare, and other causes. It provides a negative easement in recognition of the principle that every person must use his property in such a way that he does not cause injury to others. We now have the last easement. legal easement of lateral and subjacent support. No proprietor shall make such excavations upon his land as to deprive any adjacent land or building of sufficient lateral or subjacent support. So the legal easement of lateral and subjacent support is not only for buildings standing at the time of the excavations are made, but also for constructions that may be erected. Any proprietor intending to make any excavation should notify the owners of adjacent lands. It is a limitation on the surface rights of the owner. Between adjacent landowners, each has the right to be laterally supported by the soil of his neighbor. Remember the case of Castro versus Monson, in which there are adjacent landowners, which house, respective houses are um, not of the same level. Okay, one is higher than the other, and the other, the one in the higher level, in the lower level, um, once excavated this property. The adjacent owner complained and had the easement of lateral and subjacent support annotated in its title. Supreme Court said there is no need to annotate it because it is a legal easement, it exists by law, and that adjoining property owners are entitled to lateral and subjacent support, and they are entitled to be supported by the land of the adjoining owner. But there is no need to have it annotated. So that's it for easements. Thank you for listening.